This honorable court is now in session. Please be seated. Thank you. For the record before the court is the continuation of the trial in the matter of Commonwealth versus Aaron Hernandez on docket 14-10417 and 15-10384. Mr. Hernandez is present in court. He's represented by attorneys Jose Baez, Ronald Sullivan, George Leontire, Robert Proctor, Linda Kenny Baden, and Michelle Medina. The Commonwealth is present. They're represented by Assistant District Attorneys Patrick Hagan, Mark Lee, and Teresa Anderson. Good morning, Your Honor. All members of the jury are present.
Well, good morning, folks. Welcome back. Let me inquire of all our jurors now seated, the 15 of you, whether any juror has discussed this case, has read, heard, or seen anything about this case, or has heard anything about this case since you were last with us. If any juror has read, heard, seen, or discussed this case, would you raise your hand? In seeing no hands raised, I find the jurors remain indifferent. And that is a question that I will put to you each day as we start, simply to see whether any juror has been exposed to any outside information or influence. Seeing no response and finding you remain indifferent as the jurors in this case, we now proceed with the trial proper, turning first to our clerk, Mr. Sheehan.
Your Honor, may the jurors be sworn?
They may.
Will each of the jurors please rise and raise your right hand? Do each of you solemnly swear that you shall well and truly try and true deliverance make in the issue now pending between the Commonwealth and the defendant at the bar, whom you shall have in your charge, according to the evidence, so help you God? Yes. Thank you. You may be seated. Your Honor, may I proceed with the formal reading of the indictments?
Please.
Will Mr. Hernandez please rise? Members of the jury, hearken to the following indictments. 2014-10417, offense 001, charging murder in the first degree. The Commonwealth of Massachusetts, Suffolk to wit, at the Superior Court Department of the Trial Court for Criminal Business, begun and holden at the City of Boston within and for the County of Suffolk, on the first Monday of May in the year of our Lord 2014, the jurors for the Commonwealth of Massachusetts, on their oath, present that Aaron Hernandez, on July 16, 2012, did assault and beat Daniel D'Abreu with intent to murder him, and by such assault and beating did kill and murder Daniel D'Abreu. With respect to indictment 2014-10417, offense 002, charging murder in the first degree, the Commonwealth of Massachusetts, Suffolk to wit, at the Superior Court Department of the Trial Court for Criminal Business, begun and holden at the City of Boston, within and for the County of Suffolk, on the first Monday of May in the year of our Lord 2014, the jurors for the Commonwealth of Massachusetts, on their oath, present that Aaron Hernandez, on July 16, 2012, did assault and beat Safiro Furtado with intent to murder him, and by such assault and beating did kill and murder Safiro Furtado. With respect to indictment 2014-10417, offense 003, charging assault with intent to murder armed, the Commonwealth of Massachusetts, Suffolk to wit, at the Superior Court Department of the Trial Court for Criminal Business, begun and holden at the City of Boston, within and for the County of Suffolk, on the first Monday of May in the year of our Lord 2014, the jurors for the Commonwealth of Massachusetts, on their oath, present that Aaron Hernandez, on July 16, 2012, being armed with a certain dangerous weapon, to wit a firearm, did assault one Aquilino Freire with intent to murder him. With respect to indictment 2014-10417, offense 004, charging assault with intent to murder armed, the Commonwealth of Massachusetts, Suffolk to wit, at the Superior Court Department of the Trial Court for Criminal Business, begun and holden at the City of Boston, within and for the County of Suffolk, on the first Monday of May in the year of our Lord 2014, the jurors for the Commonwealth of Massachusetts, on their oath, present that Aaron Hernandez, on July 16, 2012, being armed with a certain dangerous weapon, to wit a firearm, did assault one Gerson Lopes with intent to murder him. With respect to indictment 2014-10417, Offense 005, charging assault with intent to murder armed. The Commonwealth of Massachusetts, Suffolk to wit, at the Superior Court Department of the Trial Court for Criminal Business, begun and holding at the City of Boston, within and for the County of Suffolk. On the first Monday of May in the year of our Lord 2014, the jurors for the Commonwealth of Massachusetts on their oath present that Aaron Hernandez, on July 16, 2012, being armed with a certain dangerous weapon, to wit a firearm, did assault one Raishides Sanchez with intent to murder him. With respect to indictment 2014-10417, offense 006, charging assault and battery by means of a dangerous weapon, the Commonwealth of Massachusetts, Suffolk to wit, at the Superior Court Department of the Trial Court for Criminal Business, begun and holding at the City of Boston, within and for the County of Suffolk. On the first Monday of May in the year of our Lord 2014, the jurors for the Commonwealth of Massachusetts on their oath present that Aaron Hernandez, on July 16, 2012, did commit an assault and battery upon one Aquilino Freire by means of a dangerous weapon, to wit a firearm. With respect to indictment 2014-10417, offense 007, charging possession of a firearm, not home, work, no license. The Commonwealth of Massachusetts, Suffolk to wit, at the Superior Court Department of the Trial Court for Criminal Business, begun and holding at the City of Boston, within and for the County of Suffolk. On the first Monday of May in the year of our Lord 2014, the jurors for the Commonwealth of Massachusetts on their oath present that Aaron Hernandez, on July 16, 2012, did unlawfully and knowingly have in his possession a firearm, to wit a .38 caliber revolver, as defined by General Laws, Chapter 140, Section 121, that is a firearm, that is a weapon from which a bullet could be discharged and of which the length of the barrel was less than 16 inches. The said Aaron Hernandez not being present in his residence or place of business, not having in effect a license to carry firearms issued under General Laws, Chapter 140, Section 131 or 131F, and not complying with the provisions of General Laws, Chapter 140, Section 129, subsection C, and 131, subsection G. And with respect to indictment 2015-10384, offense 001, charging witness intimidation, the Commonwealth of Massachusetts, Suffolk to wit, at the Superior Court Department of the Trial Court for Criminal Business, begun and holding at the City of Boston, within and for the County of Suffolk. On the first Monday of May in the year of our Lord 2015, the jurors for the Commonwealth of Massachusetts on their oath present that Aaron Hernandez, on February 13, 2013, did directly or indirectly willfully threaten or attempt to cause physical injury, emotional injury, economic injury, or property damage to another person, to wit Alexander Bradley, who is a witness or potential witness at any stage of a criminal investigation, grand jury proceeding, trial, or other criminal proceeding of any type, or a person who is or was aware of information, records, documents, or objects that relate to a violation of criminal statute, or a violation of condition of probation, parole, or bail with the intent to impede, obstruct, delay, harm, punish, or otherwise interfere thereby, or do so with reckless disregard with such a proceeding. To these indictments, the defendant at the bar has pled not guilty, and for trial places himself upon the country, which country you are. You are sworn to try the issues. If he is guilty, you will say so. If he is not guilty, you will say so and no more. Members of the jury, hearken to the evidence.
Counsel, be seated. Members of the jury, with the formal reading of the indictments, this trial is now underway. And Mr. Sheehan just read the 8 separate charges in this case. He read them according to the formal language that we use in a charging instrument, that is, in the piece of paper asserting the charge, and we call that an indictment. And you may have noticed the language of that indictment includes the language, the jurors for the Commonwealth of Massachusetts on their oath present that Aaron Hernandez, and then describe the particular crime at issue. That is, the 2 separate charges for murder in the first degree relating to Daniel De Abreu and relating as well to Safiro Furtado. And then 3 separate charges for armed assault with intent to murder, again relating to Aquilino Freire, to Gerson Lopes, and to Rashides Sanchez or Sanchez Gomez with the intent to murder them. The next charge being an assault and battery by means of a dangerous weapon, relating to an assault and battery upon Aquilino Freire. That's a fancy way of saying shooting Mr. Freire, but not causing death. The next charge being the defendant unlawfully possessed a firearm outside of his home or place of business, and the charge of intimidation of a witness or potential witness relating to Alexander Bradley. And going back to the language of those separate charges, the language being the jurors for the Commonwealth of Massachusetts on their oath present those charges. Understand what that language means. That language references what is known as a grand jury. A grand jury sits to determine whether there's a basis to issue a charge. And that's all a grand jury does in the context of setting forth a charge in an indictment. A grand jury does not determine guilt or innocence. That is not their function at all. That function rests with you. You are the trial jury in this case. It is your responsibility to determine from the evidence presented whether the charges, one or more or all or none, have been proved beyond a reasonable doubt from the evidence presented in a courtroom and according to the law as I would instruct it. So please understand, the fact that charges issued and that language doesn't indicate anything. It does not suggest anything regarding guilt or innocence. It is merely the formal language that we use to bring a defendant before the court and to advise that defendant of the charges that have been lodged. And then the charges, the indictments, frame the issues to be presented at trial. The fact that an indictment has issued is not evidence of anything. It does not affect in any way the presumption of innocence that I have discussed with each of you and have explained previously. The defendant comes before the court. Mr. Hernandez comes before this court, presumed innocent of these offenses and entitled to a verdict of not guilty and acquittal, unless or until you unanimously agree that the Commonwealth has proved its case, its claims, these charges, beyond a reasonable doubt. And if the Commonwealth fails in that burden of proof, then by virtue of the presumption of innocence, the defendant is entitled to an acquittal, must be acquitted by way of a verdict of not guilty. On the other hand, if the Commonwealth does sustain its burden of proof and demonstrates beyond a reasonable doubt that the defendant committed the crimes charged, then your verdict must be guilty. You will make those determinations based solely on the evidence you are to hear in this courtroom and not based on anything else. And in making that determination, you will apply the law that I will explain to you before you commence your deliberations. Now understand, in any courtroom, there are 2 judges. I suppose I'm the more obvious only because I sit up here on a raised bench and I wear a black robe, and I am one of the 2 judges. Collectively, you are the second judge, and together you and I will resolve this case. While we're both judges, our functions are different. My function as the judge in this case is to preside over the trial, to ensure that we proceed in a fair, orderly, and efficient manner, meaning that we use your time wisely, that while you're here, we are actually receiving evidence in the courtroom. It is also my responsibility to rule on what you may consider as evidence. And I do that by ruling on motions by the attorneys or by ruling on objections by attorneys during the course of the trial. So I'll determine what evidence is in the proper form under our technical rules for you to consider. Just by way of highlight, during the course of trial, questions may be put to a witness or something offered as an exhibit, and the other side may stand up and say, objection. And understand, if that happens, it doesn't mean that counsel are trying to hide anything from you. It is the attorney's responsibility. It's part of their function to object if they believe that a question put to a witness or the anticipated answer from a witness or some exhibit as offered is not in the proper form under our technical rules. And then I will rule on that objection. If I overrule an objection, it simply means, in my mind, either the question or the anticipated answer or the exhibit does conform with the rules such that the witness may answer the question or the exhibit may be received. If I sustain an objection, it simply means, in my view, at that point in time, for some technical reason, either the question, anticipated answer, or an exhibit is not in the proper form as of that moment, and a witness would not be permitted to answer a question. On occasion, when an objection is posed, I may meet with the attorneys at what we call sidebar, which is the far edge of the bench here, and we'll all huddle over there. When we do so, we will whisper, and invariably one of you will later complain about how rude we were, that we were whispering and you couldn't hear what we were saying. Understand, we whisper precisely so you don't hear what we're discussing, because we're discussing whether the evidence is in the proper form for you to hear it. And it would defeat the purpose entirely if you were to hear that evidence before I had ruled. When we're at sidebar, that is the one opportunity you will have to pay no attention to what's going on in the courtroom. Take a mental stretch break. Indeed, if you want to stand and stretch, feel free to do so. Understand we're not there very long, but you need not focus on what we're discussing. Now, my third role as judge is to be the judge of the law. And so before you deliberate, at the close of all the evidence and before deliberations commence, I will give you formal legal instructions. By that I mean I'll explain to you how you go about your function of determining the facts in a case. And I'll explain the elements, being those things the Commonwealth must prove beyond a reasonable doubt as to each specific charge. And I'll give you those full and formal legal instructions before you deliberate. Now, those are my principal functions. Let's talk a little bit about your function as a judge in this case. You are the sole and exclusive judges of the facts of this case. You'll determine the facts of this case from the evidence as it's presented and as you weigh it, assess it, and determine whether to accept it in whole or in part. It is your function, one of your jobs, to determine which witnesses you believe or how much of any one witness's testimony you do believe. And in that regard, you are, as I said, the sole judges of the so-called credibility or believability of the witnesses. It is your function to listen carefully to the witnesses as they provide their testimony and to determine from that testimony and from the other evidence in the case what facts have been demonstrated. So that's your principal function in this case. Now, bear in mind, as of this moment, You've heard no evidence in this case. Nothing that has occurred up until this moment is to be considered as evidence. And when I say nothing, think about what that might include. I met with all of you now almost 2 weeks ago downstairs in our jury pool and gave an overview of the allegations. And those allegations were also set forth in the questionnaire that you all completed. Those allegations are not evidence. Then we met with each of you and had some questioning in individual voir dire in the selection process. And to the extent counsel referenced anything about the anticipated evidence, nothing the attorney said through that process, nothing I said through that process is evidence. You haven't heard any evidence as of this point. Please understand that. Let's talk about what the evidence is. Evidence typically comes in one of three forms. One form or type of evidence is the sworn testimony of a witness. And a witness is simply someone who comes into this courtroom, takes an oath to tell the truth, and then from the witness stand right at the end of the bench provides you information. And a witness provides information in response to questions that are posed by the attorneys. The attorney, the party that calls the witness forward, conducts the first round of questioning, and that is known as direct examination. And at the end of that direct examination, then counsel for the other side, the opposing party, will have the opportunity to question the witness, and that is called cross-examination. So you can expect any witness called will be subject to direct examination and likely subject to cross-examination. Sometimes, during a cross-examination, there are issues raised that were not part of the witness's earlier direct examination, not part of the questions posed by the first lawyer. And if that happens, then we permit that first attorney to conduct further questioning in what is called redirect examination, limited to new matters that were raised by opposing counsel. And then, because sometimes new matters may arise in redirect examination, we sometimes permit what is known as recross examination. Again, limited new matters. Now, theoretically, that could go on forever. Now, one of my jobs is to make sure that it does not, that any further questioning of a witness is truly related to something newly raised by opposing counsel. But getting back to the main point, the testimony of a witness is evidence that you will use to determine the facts of a case. And a second form of evidence is what we call an exhibit. An exhibit is some physical or tangible object or item. It might be, for instance, a photograph. Could be some sort of record or report. Might be an object of some sort, clothing, in this case, an alleged firearm or gun. It's some physical, tangible item that is offered into evidence, and if received, is given a number. And we number exhibits sequentially, 1, 2, 3, so forth and so on. Exhibits are evidence. Sometimes during the course trial, an exhibit is introduced and counsel want you to see it, and it's shown to you. We call that publishing the exhibit. For instance, a photograph might be held up and displayed for you all to see. It could be that it's put onto the video monitors that are around the courtroom so that you can see that exhibit. Could be asked that it be passed through the jury box. And I would expect that that will occur in this case, as do some of the exhibits. But sometimes exhibits are received in bulk form, say a stack of records, and you don't have the opportunity to see them at the time they're introduced. Don't worry about that if it happens. When you deliberate, all of the exhibits in the case will be sent to the jury room. And so during deliberations, You will have the opportunity to examine every exhibit to whatever extent you deem helpful and appropriate. Now, in addition to the testimony of witnesses and any exhibits that are introduced, a third form or type of evidence is what we call a stipulation. A stipulation is an agreement between the two sides. They may stipulate or agree that some fact is true, and then announce it by way of stipulation. And if that occurs, that agreement, that stipulation is evidence. And you may accept whatever the fact or event that's part of that stipulation as evidence. Indeed, you may accept it as true. You don't have to decide whether to believe it or not, because both parties are agreeing to the stipulated fact or event as true, and then build upon that in determining the overall facts of a case. So those are the three principal forms of evidence that we see in our courtrooms. Nothing else that happens during a trial is to be considered as evidence, unless I tell you specifically that it is. Now, when I say nothing else, what does that mean? Well, that means everything that's happened already. During the impanelment process, the things that were said or reported or alleged are not evidence. We begin the trial in just a few minutes with the opening statements of the attorneys. An opening statement is counsel's opportunity to give you an overview of what they expect the evidence may or may not show. An opening statement's been described as something like looking at the cover of a jigsaw puzzle box before you begin assembling the puzzle. It gives you an idea of what the big picture is supposed to look like. And then as you deal with each individual piece of the puzzle, you have some context for where it might fit. And that is the essential purpose of an opening statement, to give you that big picture for the Commonwealth as to what they allege has occurred, what they allege the facts to be. For the defense, an opportunity to indicate to you any weaknesses in that picture or any contrary picture that may exist through the evidence. But an opening statement is not evidence. And at the close of the case, we will have what are called closing arguments. Counsel's opportunity to review with you what the evidence has been, and then to argue to you. By that I mean to attempt to persuade you as to what conclusions you should or should not draw from the evidence you've heard. And through the course trial, the attorneys will be questioning witnesses, asking questions, and so forth and so on. Nothing that counsel say is to be considered as evidence. Counsel are advocates. They are not witnesses. So nothing the attorneys say during the course of trial is to be considered as evidence unless it involves announcing a stipulation. And other than that, counsel's role is as an advocate, not as a witness, and what they say is not to be considered as evidence. Now, jurors sometimes find it helpful to take notes during the course of trial. And I'm going to have notebooks provided to each of you so that you can take notes as you deem appropriate during the course of the testimony of the witnesses and during the presentation of the evidence. Let me give you a couple of cautionary instructions, though, with regard to note-taking. First, any notes that you take are personal to you and you alone. That is, any juror's notes may assist that juror only in determining what the evidence has been. You're not to use your notes to attempt to convince other jurors as to what the testimony was. The notes serve you and only you in recalling the evidence as you've heard it. Second, unless you're certified in shorthand, I suggest you not attempt to write down verbatim everything that is said during the trial. I think I can safely assure you, you can't write as fast as the human tongue can move. And if you try and write down verbatim every question, every answer, you'll become hopelessly mired in note-taking. More importantly, you'd be so focused on notes that you'd lose the opportunity to observe the witnesses as they testify. And there's a reason we require witnesses to come into the courtroom to give their information, their testimony. And that's so that you may see them, so that you can observe them as they testify. And think about how you go about deciding whether you believe what someone tells you. Often it's not only what is said and your assessment of what is said, but it's your observation of a person as they tell you whatever it is they're telling you. That is, you size them up. You observe their demeanor, the manner in which they testify. You draw some conclusions or impressions about whether it appears that the witness is being open and honest, or perhaps trying to conceal or fudge something. So don't lose the opportunity to observe witnesses as they testify and to make note of the manner in which they testify. With regard to note-taking, you might find it helpful perhaps to note a date or a time or a location or some concrete detail that will help you later in recalling what it was that witness said and the precise details of the witness's testimony. But again, don't become so focused on notes that you lose the opportunity to observe witnesses. At the end of each day, your notebooks will be collected by the court officers and safeguarded until the following morning and then returned to you. At the conclusion of the trial, your notes will be destroyed and generally will not be examined by anyone. They're personal to you and you alone. Now, as I indicated, this trial will take some period of time. We talked about possibly 4 to 6 weeks. We'll see if it goes that long. Hopefully, we can resolve it expeditiously. As I indicated, for the most part, we'll be trying this case on what we call a full court day schedule. That is, starting as close to 9 a.m. each morning as we can and proceeding until 4 p.m. each afternoon with the presentation of the evidence. That doesn't mean you're sitting there for 7 hours. We have pauses built into the court day. If we start close to 9, we generally will take a morning recess somewhere around 11 o'clock for 15 to 20 minutes. It's an opportunity to get a little refreshment and just take a pause in the evidence. And then we'll resume after that morning recess and proceed until 1 o'clock. The established court lunch hour is from 1 to 2 p.m. And for your convenience, we're going to have lunch provided each day up in the jury room for each of you. And then at 2 p.m., we resume with the presentation of the case and proceed until 4. Sometimes we may take a stretch break at 3 o'clock. Now, those are the scheduled pauses during a court day. If any juror at any other time needs a break, you need a recess, for whatever reason, let us know. Let me know by just raising a finger. Between Mr. Sheehan, myself, our court officers, one of us will notice. We may not do anything about it, but you'll feel good. You had a chance to wiggle a finger. As well, it is critically important that you're able to hear everything that is said during the course of trial, with the one exception of sidebar conferences. Sometimes witnesses lean back, drop their voice. Sometimes trucks go up and down the street, and it becomes difficult to hear. If any juror at any time has difficulty hearing a witness, counsel, or me, let us know if you would by, again, just raising a finger, cupping your ear, and I'll ask the witness or counsel to raise their voice and to speak up. Now, let me explain a little bit about the sequence for the trial, that is, how cases proceed. As I indicated, we begin a trial with the opening statements of the attorneys. The Commonwealth goes first, and then the defendant has the opportunity to give an opening or may wait and give an opening later. After the opening statements of counsel, we begin with the presentation of the evidence. Now, remember what you all were told earlier. In a criminal case, the Commonwealth has the burden of proof. The Commonwealth must prove its case beyond a reasonable doubt. A defendant in a criminal case has no obligation to present any evidence because a defendant presumed innocent does not have to present any evidence to disprove the charge, the burden at all times being on the Commonwealth. But because the Commonwealth has the burden of proof, it must present evidence. There's no other way to meet its burden of proof. So we begin the presentation of the evidence with hearing all the witnesses, receiving all the exhibits, or hearing all the stipulations on behalf of the Commonwealth. And the Commonwealth continues presenting its case until such time as Mr. Hagan, Mr. Lee, and Ms. Anderson determine that they've given you all their evidence. And then they'll tell us they're done. And they tell us that by saying the Commonwealth rests, meaning all the evidence the Commonwealth deems appropriate to determine the facts of the case has then been presented. And at that stage, a defendant, the defense in this case, has the opportunity to present evidence. Notice the difference, though. It has the opportunity. It does not have the burden to do so. But if the defense has evidence to present, that is, witnesses or exhibits or stipulations, we proceed in the same fashion, hearing all the evidence on behalf of the defense, until such time as Mr. Baez and his co-counsel determine that they put forward whatever evidence they believe is appropriate. And then they will tell us they are done by announcing the defense rests. On occasion, there may be rebuttal evidence, but if not, that will close the evidence in the case, and then we'll proceed to closing arguments, and then to my instructions of law, and then to the deliberations of 12 of the 15 of you. A deliberating jury in the Superior Court is 12 in number. We pick or select more than 12 so that at the end of the case, we hopefully have 12 remaining jurors because experience shows that sometimes people, for some reason during the course trial, can't continue as jurors. They get hit by a bus on the way to court or become ill or for some reason aren't available to continue, and so we pick alternates in case some juror becomes unavailable during the course trial. So 12 of the 15 of you will be deliberating upon the evidence. 3 of you will be selected as alternates. We don't know at this stage who is a deliberating juror and who is an alternate. So don't any of you think that you don't have to listen or pay attention because you're going to be the alternate. We don't know that. At the close of the case, before you deliberate, what we're going to do is place all of your names or seat numbers into a barrel. Mr. Sheehan has a very fancy barrel here. And we'll place your names or numbers into that barrel, spin it around, and draw out 3 numbers, seat numbers. And that will determine who alternates are. So you all have an equal chance of being a deliberating juror, and similarly, equal chance of being an alternate, but that will not be known until the close of the evidence. Now let me talk a little bit about your function as jurors. It is your function. It is part of your oath. It is your duty to give your full and undivided attention to the attorneys as they present the evidence in this case. It is your function, duty, and responsibility, and oath, to remain fully fair and impartial as jurors throughout this trial. And it is your duty, function, and responsibility to keep an open mind throughout the trial. And by that I mean, don't begin to judge or prejudge the facts of this case until you've heard all of the evidence. And think about that for a minute. It makes abundant good sense. It would be fundamentally unfair if you formed judgments about what's been proved before you'd heard all the evidence, everything. So you must keep an open mind throughout the trial. And you'll have plenty of opportunity during deliberations to begin to form the judgments that you must make as to what facts have been proved and prove to what level of proof. Now, to ensure that you keep an open mind, that you remain fully fair and impartial, and that you decide this case only on evidence that is presented in the courtroom, there are instructions that you must follow during your service as jurors. There are instructions that you all received in written form when you first came in or when you left after your first day here, and were given a written set of instructions regarding contact or communication outside of court. It is a bedrock principle of our court process that cases be decided only on evidence presented during the trial and without consideration of any other information or material. So you cannot have any contact with the case outside of court. You cannot discuss this case with anyone during your service as jurors. And let me break that down into two parts. First, to ensure that you keep an open mind throughout the presentation of the evidence, you're not to discuss your views about the case with one another during the presentation of the case. You'll have that opportunity during deliberations, but not before then. And that's to ensure that you keep an open mind. So please, during breaks or when you arrive in the morning or leave at the end of a day, don't discuss what's occurred, what the evidence has been with each other. You'll do that during your deliberations. And more broadly, do not discuss anything about this case with anyone else during the course of trial. And I know that becomes difficult. You all filled out questionnaires when you first came in and then went home or went back to work, talked to co-workers, family, and friends. And I'm sure they said, well, what happened? Were you picked? And if you're asked that by anyone, you certainly may tell them you're serving as a juror on a case. They're going to say, well, is it a criminal or a civil case? And you may certainly tell whoever you're talking to, you're a juror on a criminal case. And then they're going to say, tell me about it. And it's at that point that I instruct you not to discuss the case. When I say not discuss the case, not discuss anything about the case, including the name of the case. As you all know by now, this is a case that has received extensive coverage in the media, on television, on radio, in newspapers. And it's been the subject of a great deal of online discussion on various websites and Facebook or Instagram or whatever all those sources are. It's been there. I hate to tell you this, but there's some inaccurate information online. It's not all true. And there would be a tremendous risk if you were to see something online or in the newspapers or in the public arena that was different or separate from the evidence that you've heard in the courtroom. You cannot be influenced and cannot be exposed to any outside information about this case. And this is a case that I would expect will be covered by the media if not on a daily basis, almost on a daily basis, over the course of the next month or a month and a half. So I must ask you to avoid any exposure to news coverage of this trial, whether by newspapers, by the evening news, by radio. If by chance you see a headline, put the paper down, put it away. If something comes in the news, turn the channel. If something is on the radio, turn the volume down. Please do not have any exposure to the case outside of court. You'll notice in this courtroom right now, there is a camera. And our courts are public proceedings. That is, the public is invited in, and that includes the press. Part of the First Amendment is the right to cover matters of great public interest, and this appears to be one of those matters. So I would expect that this case will have some interest to the media and will be televised at certain points. I want to assure you folks we have some rules regarding broadcasting or filming or photographing of court proceedings. As far as you're concerned, the most important is this. We do not allow any photographs or any filming of jurors at any time. That includes when you arrive, when you leave, and while you're in this courtroom. So to those of you who may have gone to a salon and had a makeover for trial, that's nice, but it was not necessary because you will not be filmed during the course of this trial. And that's to ensure that you all remain and feel comfortable in this courtroom and not worried about any public exposure. With regard to this case, sometimes information is portrayed in the broadcast world or in newspapers that contains details that are not part of the evidence in this case. And some of you may know or think you know things about this case or things about Mr. Hernandez that will not be part of the evidence in this case. And as to those who may be aware of Mr. Hernandez or other matters, we've talked about that during the individual selection process, and I have your guarantee, your assurance, your oath that you will not be influenced or affected by any outside information. Some of you may know or think you know certain things that other jurors do not know. So it is critically important that no juror discuss with any other juror or with anyone else any information that you may have from sources outside of the evidence in this case. Because when you deliberate, you must decide this case solely on the evidence that has been admitted in this trial and not based on any other information or any other source of information. So please don't read anything about this case, don't see anything about the case, don't hear anything about the case, and don't discuss anything about the case during your service. And I know that is a difficult limitation, but it is critically important that you abide by that limitation during your service. Finally, don't attempt to learn anything about this case on your own. We now live, I guess, in a computer age where many seem to get their information online, and it becomes almost irresistible to want to jump online and start Googling names or locations or events and want to learn about them. And as I said, there is some inaccurate information out there in the World Wide Web. You're not to attempt to learn anything about this case on your own. You're not to investigate anything about the issues in this case on your own. All the evidence that you will need to decide this case will be presented in this courtroom and during the formal presentation of the evidence. Now that concludes my preliminary instructions. And I think we're prepared for the opening statements of counsel, and we turn to the Commonwealth. Hold on one second. You may. Be excused.
All rise, please.